Hey everybody, Sean Bukowski here. Hope you're having a great week. I want to talk a little bit of something different this week. We're kind of coming into an uncertain time in the economy. I think it's not news to anybody that a lot of people have talked about, a recession and whether we're going to see that in 2023. And we've kind of noticed in my practice, one of the things we do, obviously we talk about this a lot, is we do real estate litigation in our practice, and we've seen an uptick in litigation in the last few weeks. And unfortunately, it wouldn't surprise me if we see more of that in 2023 because litigation generally follows uncertain times in the economy. And so I want to talk a little bit about something that people might not know too much about. It's called the Deceptive Trade Practices Act here in Texas, and it can really be a great tool for a real estate company, investor, builder who is trying to deal with a deceptive or a vendor that they are having issues with. So what is it? With the Deceptive Trade Practices Act, it's really a Consumer Protection Act enacted in Texas that helps consumers when they're faced with, like I said, a vendor or somebody selling goods or services, doesn't matter what good, doesn't matter what services, and have engaged in some kind of deception, misleading, potentially fraud during the sale or performance of the duties under their contract. And a key is you have to be a consumer, but that's a pretty broad definition. As long as you're purchasing or leasing goods or services, like I said, doesn't matter what kind of goods or services they are, doesn't matter if you're an entity, an individual, whatever, then you can avail yourself of the DTPA. And what it does is it allows you to sue somebody if they've engaged in deceptive trade practices. And there's a whole list in the DTPA of examples of what that is. And you can go through and look at it yourself. I think I've listed a couple in the blog article this week, but it really is a good way to show it really shows some examples of what deceptive, misleading acts they're kind of referring to with the DTPA. And if you're engaged in somebody, if you're with somebody who's doing those acts, you can potentially sue them if you're a consumer, like I said. And the good thing is you don't necessarily have to prove intent. There's some of those that you have to prove intent with, but for the most part, intent is not a requirement as long as they're acting deceptively. But if you do prove intent, I think knowingly or willingly, then you can get up to three times damages. Call them treble damages. That's why I stumbled there. 3 times damages. So it's really an effective sword if you're dealing with a sort of unruly vendor in the real estate industry. And we know we've used it for people buying homes or vendors providing goods or services to investors and builders. We've come across this a lot and used it a lot. So think about it. Unfortunately, if you're facing that situation where you have some litigation that you might be facing, think about how the DTPA can potentially help you in that litigation and really get you to get potentially to a resolution of your claims. Thanks a lot. Hope you enjoy this. Please, if you like it, subscribe to our blog, our YouTube channel, our podcast, and have a great week.